Hello everyone. With exams around the corner, I thought I'd take the opportunity to go through some evaluation tips with you for your exams. Now, the information that I'll be going through in this PowerPoint relates directly to OCR A Level Law exams, but of course the tips for essays are quite general and can be applied across a number of different courses. Also, if you study AQA law or other law courses, then you will also find the content helpful. So, as you know, for OCR law, the A level unit 01, which is the criminal law unit, you now have, with the recent changes in the specification from 2020, 4 essay areas. These are non-fatal offences, consent, self-defence, and intoxication. I have covered non-fatal offences and intoxication in quite some extensive detail on other tutorials, so please watch those if you need a refresher of the law application and evaluation as well. In this tutorial, I aim to look at consent and self-defence in more detail, partly because for this year that I'm recording this, which is 2022, consent and self-defence are to be the only essays that you need to revise for, and that's because the specification has temporarily been decreased to take account of the recent pandemic. So for those of you that are sitting the exams this year, you should have a condensed version of what to expect. So I'm going to cover consent and self-defence in this. What I wanted to do first of all is just to go through some general evaluation techniques with you. And the first thing that I think is important to do is to talk you through the themes that you could be asked to cover during an exam. Now, those of you, and hopefully most of you, aiming for AA star will understand that when you write an essay, you need to keep it relevant to the question. So you always need to link back to the question. So essay questions typically start with the word discuss, which requires usually a balance. So you need to give pros and cons for something, for example. So the question would be typically discuss whether the law of consent or the law of self-defence or the law of non-fatal offences or the law of intoxication is. And then what OCR in particular have helpfully given students and teachers are a number of themes. So these are the themes that they want you to be specific to write to. So they may ask you to discuss whether the area of law is just or unjust, and of course that means justice. If a law is just, then it's going to provide justice, perhaps for individuals, for the public in general, maybe for defendants. Or perhaps there are aspects of the area that are unjust. With these themes, you shouldn't ever just give points as to an area of law being just or fair or effective. You should always try and at least give counterpoints as well. Okay, so I'll talk to you a bit more about that later. So the themes are just or unjust, fair or unfair, effective or ineffective, fit for purpose or unfit for purpose, based on sound moral principles, or whether the area balances principle with policy. And usually, commonly, the question ends with and is in need of reform, which requires you to finish with some suggestions for improvement in the area. And as you may know now, the essays for OCR are 20 marks, and I believe that is the same for AQA as well. So what this does is this gives you a focus when you're planning to write your essay, whether that's for homework or for the exam, which of course means it's more time pressured. You have at least 5 minutes built into your time in an exam to plan. You could take up to 10 minutes technically, because for OCR you should allow yourself half an hour, and that's without any extra time you may be eligible for, but you should allow yourself half an hour to write an essay, and that should include planning time. I will give you a little tip about how you can link back to these. But if you look at these themes, you could relate any issue of law back to these themes. You could pick out an issue with consent or an issue with self-defence and say that that makes it unjust or unfair or ineffective or unfit for purpose. Maybe not based on sound moral principles. Maybe it doesn't balance principle with policy. Students, I think, often get a little bit stuck with the last two themes. Now, if something's based on sound moral principles, then one would assume that it would tie in with our shared values. Those of you that have studied the OCR Law course hopefully will have studied the nature of law topics in units 3 or 4, where you have to look at the relationship of law with morals, and you'll be looking at different areas of law and deciding whether they align with morals or whether they clash with moral principles. In order to do that, you have to have an understanding of what sound moral principles are and where they come from. And of course, now that we live in a pluralist society, we have a variety of different cultures, backgrounds, etc. There is a slight variation on that. We could all commonly agree that offences such as murder, theft, and largely those that harm people, maybe even fraud, are immoral. So we agree that they're illegal and immoral, but there may be some areas where we might think that these clash, these don't align. So maybe an area of law is illegal, but perhaps we actually believe that it is moral. And an area like euthanasia, assisting somebody who genuinely wants to end their own life, which is illegal, you could be charged with assisting someone to commit suicide. Many people believe that that should be legalised, and it is the moral thing to do to help a loved one. So what you're considering here is whether these areas actually fit with the public's view. Okay. The balances principle with policy is about, again, the relationship of law with the public. So where you have legal principles, how do they sit with the need for courts and Parliament to protect the public? How do they sit with how the public responds and needs the law to be? Intoxication is a really good one that gives rise to this debate, because there are many aspects of the defence of intoxication that are strict. And the reason why they're strict is because the courts want to protect the public from people who are intoxicated. They don't want to provide defendants with a full defence of intoxication if the public is at risk of being harmed. So if somebody decides to go out and get drunk and then they harm somebody in the pub as a result, they will not have a defence. If they seriously injure somebody with intent or kill somebody, they may at the most have a partial defence. That is only because they perhaps can't form the mens rea due to their drunken state. So the courts may allow at the very most partial defence. And that is only because of legal principle, because we all know to be liable criminally for a crime, you have to not only have committed the physical act, but you also have to have the state of mind attached to the crime. So for these sorts of crimes, that state of mind is specific. You have to have intended to kill or cause serious harm to somebody. So there will be aspects where you might think that the legal principle clashes with court decisions, because of course the courts are there. They adopt what we call a paternalistic approach. They're there to protect the public. So there are some times where we might think, well, hang on, that goes against what the law says, but the courts are doing it to protect. And actually, consent is one that really gives rise to that as well, which we will touch upon. For reform, you should always make sure that you, when you're concluding in an essay, you also cite some reform. The Law Commission, our main independent body, that full-time body that looks at areas of law for reform all the time, they have by and large, suggested reform for every area of law out there. If you can't remember that in an exam, or you don't know the particular reforms, you should always suggest your own. So maybe the area like consent needs to be codified, it needs to be put into legislation. Maybe the area of non-fatal offences needs to be put into one act, because currently it's across multiple acts and a number of different cases cover it. Intoxication is one that is not codified. It is a common law defence, similar to consent. So perhaps that would be your suggestion, to make it clearer, make it fairer, make it more effective, make it more just. Okay, so we'll move on. Now, I did say that I'm not going to go through non-fatal offences because I have covered that in another tutorial on here, part 3 of the non-fatal offences tutorials. But what I thought I would do is just show you, based on this area, how you might want to tackle an area for evaluation and structure it. So look top right. The way that I believe you should structure your evaluation points is by making your point. So what I've done on this slide is I've thought about the area of non-fatal offences, the issues, and I've put them on the left. So there are 4 here. I've got age and piecemeal nature of law, outdated language, modern development, which I actually think is a good thing, so it's not all doom and gloom. Fourthly, sentencing inconsistencies. Now these 4 are my points. Okay, so I could start an essay by saying the area of non-fatal offences is old and it is piecemeal, i.e. it is across different pieces of law, so it's across 2 acts and multiple cases. That's my point. Generally, and this is me speaking as an OCR examiner and team leader in this area, generally you will not get an evaluation mark for that. Your evaluation starts where you talk about why that is an issue. So this is an issue because it can make the area difficult for people to understand, difficult for lawyers to find, difficult for judges to interpret, difficult for jurors, magistrates to apply in cases. It makes it very lengthy, very long-winded. It is out of date. So these types of explanations, I'm telling you why that's a bad thing, because the age of a law and the fact that it's piecemeal could be a good thing. The fact that we have the mechanism in our legal system for judges to make laws and update can actually be a positive, and that relates to my 3rd point, modern development. Judges are able to interpret a law and adapt it to current issues. So for example, if you look at my 3rd point, the information that I've put there, the explanation rather, the case of Burstow in the late 90s, in that case, the courts actually held that causing a victim depression can be charged as a non-fatal offence. Now, when the original Act came out in 1861, there was no understanding or even awareness of people suffering with depression, let alone somebody causing another to suffer with depression. So the fact that now we recognise it, but also it can be seen as an injury or harm caused to somebody, is a positive. And that's been created by a judge. Rather than waiting for Parliament to update these acts, we do have flexibility in the mechanism of precedent. The same with Chamfook, we recognise psychiatric injury. So perhaps when you've harmed somebody as a victim, they suffer with the effects afterwards. Perhaps they have post-traumatic stress disorder. They can't go out for a period of months. This is all harm, injury that they've suffered from a physical initial injury. But of course, it doesn't have to be physical now. It can be other types of injury too. The case of DICA recognises that if you transmit a sexually transmitted infection to a victim, and of course they don't know that you're doing that, you can be charged with that as well. So these are all modern developments, okay? So what I've got on the right here with these points is explanation. But what I'm also doing, which relates to my third part of what makes an evaluation paragraph strong, is I'm backing it up with law. I'm giving examples. So what I've been talking you through in terms of the modern development, modern development is my point. I'm saying the fact that we have judges who can develop the law, so we're not just restricted to Parliament, this is a good thing. And there have been positive changes. For example, the case of Dika with STIs, the case of Burstow with depression, the case of Chamfook with psychiatric injury. These are all examples that are illustrating my point and explanation, you see. So I'm not just developing, I'm not just getting further marks, but I'm also getting marks for assessment objective 1, which is your knowledge and understanding of the law. So if you were to write about how this area of law can be developed by judges and give examples of the positive changes, if you then were to link back to the question and say, therefore, this makes the area fair, fit for purpose, effective, just, whatever the theme is, you could gain 5 or 6 marks in that paragraph, maybe more, depending on the case examples. And where an essay only needs to be 20 marks, that's quite a significant chunk. That's more than a quarter of the marks that you need. So you should use this slide to form the basis of your notes for non-fatal offences, certainly for next year's round, because non-fatal offences, it's very common and I think high chance of coming up in next year's exam. And at the bottom I've put suggestions for reform. So the Law Commission has actually looked at this area multiple times. So you see 1989, 1993, 1998 and more recently in 2015. And each time they've recommended that the area is codified because, of course, it is piecemeal. So you could put that in. You could also recommend, which links to my fourth point about inconsistencies in sentencing, you could recommend that perhaps some of this sentencing is adjusted. So the non-fatal offences are based on hierarchy. A hierarchy is surrounded by injury. So you've got your low-level assault and or battery, which is either no injury or little injury, and you can receive a maximum of 6 months for each of those, up to 12 months in the magistrates' court. If you commit ABH, so you commit an assault and or battery, but you cause actual bodily harm injuries, so these are the mid-range injuries, which could include psychiatric injury from Chamfook, then your sentencing could jump to 5 years. And that is purely based on the injury, so the actus reus. That's a big jump from 6 months to 5 years with no additional mens rea. If you commit GBH or wounding, which is your serious harm, either internal injuries or external injuries with a substantial loss of blood, if you haven't intended to cause that injury, you can still receive a maximum of 5 years. So you see straight away, even though we've got a greater level of harm, level of injury being inflicted, you receive no greater sentence. And something that the Law Commission has suggested is that that extends to 7 years for Section 20 GBH or wounding. So you could write about that at the end of your essay, or you could mention it. And then the most serious, which is the Section 18, the causing of grievous bodily harm or wounding with intention to do so, jumps to discretionary life. So it shows a huge jump, not based on the injury, but based on the intent, based on the mens rea. So the hierarchy is inconsistent. Not only does it stay the same in terms of sentencing for 2 of our offences, but it jumps up to 5 years for ABH based on the actus reus, yet from Section 20 to Section 18, the sentencing jumps based on the mens rea, not the actus reus. it's very inconsistent. So I hope that slide helps you in terms of summarising that. This is another example of how you can set out your essay practice. A lot of students like to produce mind maps, and I'll show you some of those examples later. But this is an example that I give my students in terms of planning an essay. So it's a very kind of basic structured plan. You can put it on an A4 piece of paper or an A3 piece of paper. So you can start with what the area of law is at the top, and you see the first row says AO1 summary of area. So define the areas of law using the acts and cases for each element. So remember, for every essay for OCR law, you get 8 marks for AO1, Assessment Objective 1, which is your knowledge and understanding of law. So in other words, you cannot write an essay without using the key acts or cases for that area of law. So you need to know a good number of laws for this area to get those marks. If you were to put no cases in at all, but you write a good evaluation essay, your AO1 marks would be limited to 2 out of 8. So that's going to be really low. So you need to be aiming to get your cases and your acts in. For some students, they find it easier to write about the area first, which is why I put this row at the top. So you could introduce your essay by defining and describing the area of law that the essay wants you to write about, and then you can go into your evaluation. For those of you that become more sophisticated in your essay writing, what you might do is just go straight into the evaluation. So if it's non-fatal offences, the age of the law of non-fatal offences is outdated and is piecemeal. This is because, and then you start writing straight away. And when you're giving your examples, that's where, as examiners, we can credit the AO1, and it becomes more organic then. I feel like when we are assessing something, we're discussing something, we're evaluating, we want to give examples to illustrate whoever we're talking to about it or whatever we're writing. We want to illustrate the point we're making. Remember, every good lawyer backs up what they say with evidence. So you naturally will want to give examples when you're writing your essay. And that's why you don't have to put the areas, the law separately. It's better to combine it within, because you can get marks for evaluation by doing that, but also marks for law at the same time. So it's almost like duplicate marks for making the same points. And where you get your AA star is by linking back to the question. And a really easy way to do that is by simply saying at the end of each paragraph, therefore, this makes the area, and then you link back to the question. So just or unjust, fit or unfit for purpose, effective, ineffective. Students that do that link back to the question at the end of every point they make, will tick the box in terms of concluding if they forget to do a conclusion at the end, but also will receive what we put as examiners as an LNK on their paper, which is a link to the question. If you're linking to the question, you are more likely to get top level marks and therefore come out with an A or A star for that particular question. So you could have a go at using this as a plan, and what it does with these columns is it just forces you to keep developing your point. There won't always be evaluation points that you'll be able to make lots of points about. You won't be able to develop everything fully. We understand that. But this forces you to think about how much you can say. You should exhaust every point, give examples, say what it leads to, say what the issue is. It's very basic level to just say the age of the law is outdated and piecemeal, and then move on to the next one. You're not going to get any evaluation marks for that. Okay. All right, so I want to go on to consent. So I'm not going to spend a lot of time on every slide because there is a lot of text in this PowerPoint and you'll need to pause it. You might want to take screenshots. You might want to just pause it and write down these notes. This PowerPoint could take you hours to go through, and hopefully it'll give you everything you need for your essays, for your exams. So please do take your time. Don't rush through with me. Make sure you pause and you write everything down. So what you've got on this slide is basically all the law for consent that you need. So I start by saying it's a full defence and it's available to most batteries and low-level ABH offences. And of course, consent is only available where a victim has the capacity to consent and they are legally able to consent as well. We know that consent is limited. If you've learnt this area of law, it is not available to any crime where a defendant has intended to inflict harm. And what the courts said in the case of Brown and others, which was decided in 1993, they said that that was limited from basically top level ABH up. So you're looking at low level ABH and battery for consent inflicting harm upon people. You can't consent to murder or assisted suicide either. The rules of consent, and these are what we call the express or general rules, consent must be real, fully informed, and not obtained fraudulently. The courts say that consent could be fraudulent if you deceive your victim as to the nature of the act you're performing, or you deceive them as to your identity. Okay, and there are cases that illustrate that. So there was one case, the case of Tabasum, where the consent was invalid to a low-level non-fatal offence, where victims consented to a medical examination by the defendant because he told them that he was carrying out research for breast cancer when he was actually just committing a battery. In terms of act, there's the case of Dika, where victims consented to sexual intercourse but not to the transmission of HIV. So Dika deceived his victims. He tried to raise that they'd consented, but the court said no. The act that they were consenting to was not transmission of HIV. Okay. There is also a case called Oliboya from 1982, where it was held in that case that victims do not have to expressly withdraw their consent. They do not have to say no. So victims could submit to a crime, and this is more commonly in terms of sexual offences. A victim may submit, they may not say no, they may not put up a fight, and that does not mean that as a defendant you're able to raise consent as a defence. Based on the circumstances, the court will want to see how that act came about and how the victim felt, and what the defendant did or did not do in that situation. And then finally we have the implied rules. So there are situations where consent could be implied. So you're agreeing to a certain level of harm based on the activity. And as a policy decision, really, the courts allow consent for certain situations because we have to consent to some situations in everyday life. Otherwise, the courts would be hugely bogged down with lots of claims. So, for example, if you're going into a crowd, then there's a certain expectation that you will consent to maybe being shoved or pushed a little bit, unless that shoving or pushing is intentional. If you're going to go into London and you're going to travel on the tube, there is an expectation that, again, that shoving or pushing may happen. It doesn't mean that batteries are being committed unless somebody intentionally or recklessly commits that. You simply being in a crowded situation, you're agreeing to that. Consent is implied among the people in that situation, and it's the same with, say, attending a concert or something like that. So in sports, if you participate in sports, then a certain level of consent will be implied. and actually that consent goes quite far. So there are two key cases: case of Barnes, which involved a tackle in a football match, and Billinghurst, which involved a headbutt um, at a rugby match, but that was actually not within the rules of the game. So what the courts say is, unless the injury is grave, and that means really serious, and committed outside of the rules of the game, then consent will be implied. So typically, if you're injured during a tackle in a football match, that's just bad luck, and consent would be implied there. So there would be no liability for the defendant. Horseplay is a similar one where the courts will allow consent where people are what they call horsing around. It's a bit of an old-fashioned saying. We don't really say it anymore. But if you're engaged in kind of rough play with friends or family members, and even if you mistakenly believe that the victim is consenting with you or wants to play along with you, even if that's unreasonable, the courts may still allow that as a defence. And there's a quite a famous case, Jones and others, where some boys really seriously harmed one of their victims. They were throwing him up in the air, and they caused him serious internal injuries, and the courts allowed consent. And I believe that's because of the age, because they were schoolboys, they were early teens, but just shows you how far the courts were willing to go in terms of that. Of course, consent to surgical procedures, medical procedures, is implied, particularly if you're perhaps unable to give consent at the time of the operation. The courts believe that doctors and nurses will act in your best interests. Also, obtaining prescriptions, consent may be implied, even if a victim is perhaps not at the legal age to consent. There's quite a famous case called Gillick, if you look it up, where a girl under the age of 16 was prescribed contraception. She told a doctor she was sexually active. The doctor believed in that instance that the girl understood, was able to have the capacity to understand the effects of the contraception. Now her mother found out and launched a challenge. This case is called Gillick. The mother launched a challenge against the trust that oversaw the doctor's surgery, but lost. So there is a bit of a grey area there. Tattooing and branding. Now, tattooing, as you probably will know, you have to be at the age of 18 to consent. So any people that have tattoos under the age of 18 were not deemed by the courts able to legally consent, and Burrell and Harmer is the leading case on that. So the tattooist was unable to rely on the defence in that case. Branding, which is seen as an extension of tattooing, not as common as tattooing, could be allowed depending on, again, the age of the victim. And there's a leading case called Wilson, where a husband branded a wife with a W, and he raised consent and was successful on that. And I've already talked to you about low-level injuries in crowds. So consent you can split into three parts. So you can deal with the first part, which is what is it available to, and its limitations. The second part is what are the general rules, and then the third part is where can consent be implied? What are the everyday situations? Okay, so the key cases that I believe you need for consent, and there are quite a few here. These are all of the key cases that I teach. Now, consent, obviously any essay for OCR is in total 20 marks. The law, you can only receive a maximum of 8 marks. So the evaluation is more important because you can achieve a maximum of 12 marks there. Now, what I would suggest is that for any area of law that you're learning for an exam, you try to cite at least 4 or 5 cases. So, and that includes legislation, so cases or legislation. So the key law, make sure you go into an exam and you know at least 4 or 5 cases for each area of law. So you see here, there are more than that. So you could pick, say, 5 and learn them and make sure that you've got those. So you could maybe pick 2 for implied rules. Sport is always a common one, so you might want Barnes or Billinghurst. You could pick maybe 1 or 2 for the limitations and the initials. You could use some of these up here, and then you might want to pick 1 or 2 for the general rules, which are here. Okay, so I've split them. So you've got the top 4 lines are the limitations and availability, and then you've got the next 3 lines are the general rules, and then the last ones are the implied. So you could choose some. Those of you that have greater memory capacity, you're able to remember cases more. We all have different strengths. Then you might want to remember more. The more case law and legislation that you're able to put in to support your answer, of course, the more marks you'll get. So please do take your time to write these down. The FGM Act, by the way, is Female Genital Mutilation Act that prevents defendants raising consent, because in some cultures there is a procedure performed at birth on young female infants, which is referred to as mutilation of their genitals. I guess similar to where boys in some cultures are circumcised. There is an act passed because the genital mutilation of females is seen as a lot more traumatic. So, of course, that can never be consented to. Okay, I'm going to show you here the mark scheme for consent, and this is the last time that an essay on consent came up, which was 2019. If I was a guessing person, because consent came up last, it could be more likely that self-defence comes up this year, but there is no kind of rhyme or reason to that. So you only have this year 2 essays to prepare for. So I'd recommend that you give both equal time and weighting in your revision. I normally think that OCR mark schemes are brilliant, especially for scenarios, because they give you the AO1, the indicative content that they would expect. So all the key law that examiners look for and are more familiar with, which is why you should always try to learn the law that's on the mark schemes, and teachers should try to teach the law that's on the mark schemes. The AO2 indicative content for scenarios always sets out the incidents with a header, so who's injured whom, for example, and then the key areas of application underneath that with a conclusion, which I think is brilliant, and the way that we should structure our answers in an exam. But the essays, the indicative content can be a bit tricky, I think, and I mean this essay is absolutely case in point. So always beware when you're using mark schemes, and I would recommend you use mark schemes when you're revising. They always say at the top, answers may. So this is never an exhaustive list. If you talked about a different area that isn't on a mark scheme, that doesn't mean that you're not going to get marks for it. Okay, you need to assume and understand that examiners are specialists. They are experienced teachers, so we're not just going to be teaching to these areas. Okay, so you could have a quick read of these points on this mark scheme and be aware of the question. So the question was about whether the defence is fit for purpose and needs to be reformed instantly. It's one of the themes I gave you, fit for purpose. And then, of course, the common, does it need to be reformed urgently? So you need to discuss whether this statement is accurate. So basically, you need to discuss in the essay, give reasons for the defence of consent maybe being fit for purpose or not fit for purpose. It's always best to start thinking about, what is my conclusion? Do I think this defence is fit for purpose or not? Does it suit us in modern times or not? So you should have, hopefully, a view on this before you start writing, and then your essay needs to naturally lead to that point. So what the mark scheme gives you here are some what they believe are the key issues. So they believe that there's difficulties in a balance between the freedom of individuals, but also the role of what they call it social paternalism here. And this is what I referred to earlier about how the courts and Parliament adopt a paternalistic approach to society. So the laws that they make are there to protect us. But what they can do with those laws is restrict our individual freedoms, because they're saying you can't do that because that harms or could harm members of society. Whereas many of us would say, well, individually, surely if we're all consenting adults, then we can do that. The case of Brown and others really gives rise to this debate. So please do read that case. It's a 90s case about a group of homosexuals who were caught engaging in pretty serious sadomasochism, and there were serious injuries committed to each other. But this group claimed that everybody was consenting, and they were all adults, they were all over the age of 18. And when the courts decided that there was no consent, that really divided society, because there were people that were saying, surely we are, if we're adults, we're able to consent to whatever sexual type of conduct we want. And the courts should not be saying that we can't, and it's up to us. And certainly with our changing society, and you've got books and films like the 50 Shades of Grey that glamorizes that kind of conduct, sexual conduct, then perhaps that needs to be revised. So you could kind of form a paragraph about that and use that case as your basis. The later case of Emmett, R.V. Emmett, upheld the decision in Brown. But then you have other potentially contrasting decisions, like in the case of Wilson, the branding, where consent was allowed. Okay, so does social paternalism go too far? Is there a conflict? Because we all have the right to a private and family life. This comes from the Human Rights Act. So if a court is saying you can't do that, then does that impact? Okay, so those two bullet points, I think, really arise out of the same issue, which goes back to my AO1 list and structure, the limitations of consent. You cannot consent to being harmed where a defendant intends to inflict harm. So if you're engaging in sadomasochism with another party and they are using, I don't know, they're whipping you or doing something that causes you serious harm, and they're intending to do that, then the courts may say, well, there's no consent there, regardless of your age and your capacity. The third bullet point is about sports. So perhaps there's a bit of a inconsistency in terms of what amounts to acceptable conduct within the rules of a game and outside the rules of the game. I personally think the cases of Barnes and Billinghurst are pretty clear. If you headbutt somebody when nobody's playing rugby and it's at the side of the pitch, then that is, of course, outside the rules of the game. But do the rules go too far? If you're boxing, kickboxing, performing martial arts, then what are the rules there? Because, of course, you can really harm somebody. People can even be killed through that. So do the rules go far enough? Are there issues with surgical operations? What can be consented to? What should be consented to? Because currently doctors could perform emergency surgical operations without your consent. If there's no next of kin, then they could just perform those. So again, it depends on situations, and I think actually it'd be really difficult to give definitive guidance on that and legislation, because there are so many different issues. But what we do see is where doctors are concerned about carrying out an operation, if they've got time, they will go to the courts and seek direction. like in the case of Rie conjoined twins, when they wanted to perform an operation to separate the twins, they knew that one of those twins would die as a result, but the other would be saved. Whereas if they didn't operate, both would die. The doctors went to the court and asked for a declaration that that operation could be lawful, and the court said yes, even though the parents did not agree. And that started in the year 2000. So that would be quite a good case to talk about there. I touched on this before, but again, changing attitudes towards sexual activity. So sadomasochism as a result of the 50 Shades of Grey trilogy, prank TV shows, Dirty Sanchez, and other shows like that glorify inflicting harm upon people, and young people that are watching, especially on YouTube, may be more susceptible to copying that. And at what point do we then say that there is consent there? And then finally, any law reform proposals. They've also added at the bottom here euthanasia, so assisted suicide, because of course currently you can't consent, you can't help a loved one to die. Even if you travel to Switzerland, there is a risk when you come back that you may be prosecuted for taking that loved one to Switzerland, the Dignitas clinic, to help them to die. What I would say is if you look into this area in a bit more detail, since 2010, the rules have relaxed. So the courts did ask the Crown Prosecution Service to draft guidance on when they would prosecute somebody for assisting a loved one in a genuine situation to die, to end their lives. And since then, to my knowledge, nobody's been prosecuted with that crime. Okay, so I think the rules have relaxed, and that's something you may want to talk about. And it can also be a really useful topic to discuss in the nature of law part of your Unit 3, Unit 4 essays as well. So what I've done at the bottom is just picked out the key issues from this mark scheme. So you could base your planning for this essay around these points if you wanted to. So the key to essay planning is to know quickly in an exam kind of how you're going to structure it. So this is how I would kind of jot down and make my plan in an exam. I would make sure I've got the key rules and the law in there. So remember, 4 or 5 citations at least. I would talk about the limitations of consent. I would talk about the general rules, the implied rules, and then I'd make sure I conclude and I cite some reform at the end. Suggestion for reform. Okay, so on this slide, there's quite a lot of text. I'm going to just show it to you here. And what you want to do is pause, maybe take a screenshot, have a read through and take your time. So if I just explain to you what I've done here, I've pretty much written a really full essay. So I will not go through it all with you because it will be long. And to be honest, to write all of this would give you far more than 20 marks, which of course we're limited at 20. So you could pick parts out of here to use, but I wanted to give you all of it. So in the black text, you've got the AO1, so your law citations, the parts that give you the understanding of law. In the red, you've got evaluation. So see, there's a lot more red because you get 12 marks for evaluation, you get more marks. And at the end of each paragraph, I should have put linked question or theme. So make sure you're always linking back. So this therefore makes the area of law unfair or fair, just or unjust, okay? And then make sure you do an overall conclusion and suggest reform at the bottom, at the end of your essay. So I hope that you find this slide useful. Please do take your time. I understand it's a lot of text, but you can disregard obviously some of it and use the parts that you want to talk about. Okay. This slide also gives you a bit of kind of thinking, a few points, understanding about whether the law of consent achieves justice. So this could be the basis for your essay in the exam, if the question is whether the area is just or unjust. But also, I thought it would help you in relation to the nature of law part of your final exam, because justice is one of the key concepts that you need to look at. So I give you some points here to consider whether the area is just or not. So consent is a type of substantive justice. Substantive is about an area of law. Okay, so this type of justice refers to the end result, and it uses the legal principles to determine liability. So all of the rules that you learn for consent are substantive areas of law. Those of you that have learned about justice will have learned that there is another type of justice called formal or procedural justice, where you could look at the processes in courts, prior to court, the use of a jury, for example, or magistrates, the role of solicitors, barristers in giving legal representation, the right to legal funding. All of these formalities, all of these procedural things could also achieve justice, but there may be aspects of them that don't. Any area of law is what we call a substantive type of justice, but of course there are parts of these areas of law that will not achieve justice because they are unfair, unfit for purpose, etc. So I talk about the fact that it's a common law defence, which brings flexibility. I talk about how the implied rules of consent could again be flexible and lead to justice. They allow society to engage in everyday activities. There are some issues though to discuss in terms of sport and horseplay. I talk about the fact that the flexibility for doctors to act in the best interest of their patients could lead to justice. But then the part that of course is on the mark scheme for OCR, the limitations on whether you can inflict serious injury, could give rise to a debate around the rights of individuals. So there's a bit of a balance here. So do please feel free to pause this, write these down and have a think about these points. It just gives you a bit of a practice in terms of one of the themes, and it can also help you for your final exam as well. Okay, I'm going to go through self-defence now, and I'm conscious I'm talking for a long time, so I'll try and whiz through. This is your AO1 slide. All the keywords for I love a fill in the gaps. My students would know that. All the keywords at the bottom, and the key law is here. So please do try and complete this slide. If you have any questions, then please do comment on the tutorial and I'll answer them for you. So again, remember, you're aiming for at least 4 or 5 citations of law, okay? Remember that self-defence is codified. So we now have the Criminal Justice and Immigration Act 2008, Section 76 is the key. So whilst self-defence used to be a common law defence, it originated from Palmer, we do now have legislation and some requirements, and these are numbered up here. So you must make sure when you're talking about self-defence, if that is the essay, that you cite Section 76. And if you're applying self-defence in a scenario, again, you make sure that you cite Section 76, Criminal Justice and Immigration Act 2008. The defending somebody, the requirements can also be the same requirements for if you use force to defend another, or defend property, or act to prevent crime as well. Just not to forget that. Okay, so in terms of evaluation, and this is where you might want to use a mind map instead of the table that I showed you earlier, or the list of columns. So I've put self-defence in the middle, and I've got 5 key points that I would want to use to evaluate the defence. So I might want to talk about the nature of the defence. It is subjective. Now, anything that's subjective means that it's the opinion, it's based on opinion of somebody. That opinion might be a juror, magistrate, judge. So anything subjective gives rise to criticism. Okay, we always want to be objective in law. We always want to be free from bias, free from individual views. there have been a lot of criticisms, particularly over the last 20 odd years, in terms of the use of self-defence for homeowners. So if you're faced with an intruder in your home and you use force, and let's say you kill that intruder, where does the law stand? Now, there are key cases that have left the public in uproar, and there was a big media campaign 20 odd years ago by The Sun when a man called Tony Martin used force, shot a burglar in his property, and that burglar, one of the burglars, happened to be a 16-year-old boy that he shot and killed, and he was convicted of murder. He raised self-defence, of course, defending of his property, but he was unsuccessful. And that ended up being a huge story in the media, because it was, left the public worried and in uproar of, well, if we can't defend our homes, then what do we do? So the law has now been more relaxed since 2013 under the last Tory government. They passed the Crime and Courts Act, which allows people now, homeowners, to use excessive force if they feel necessary. But at the time Tony Martin was convicted, he was sentenced to life. He was released some years later based on a different offence of diminished responsibility. But this has given or created problems. So it's a big area that you could talk about in terms of development. The legislation says that you can't calculate force. And of course, we know through case law that also you can't use excessive force. Force must be reasonable. But what does reasonable mean? If you can't calculate force, then how can you be sure to use reasonable force if you can't think about the force that you're going to be used? So this defence needs to be used in the spur of the moment, under attack, and you're responding almost instantaneously to this attack, then surely it follows that you may overuse force when you respond, because if you can't stop and think, you're bound to overuse, you're bound to make mistakes. So it's a bit of an impossible defence, to be honest with you. The fact that it's all or nothing is a big criticism, particularly by the Law Commission. The jury or magistrates either believe that you acted in self-defence and therefore you walk away scot-free from the charge, or they believe that you overused force or you didn't act in self-defence and therefore you're convicted of the full crime. There's no halfway house. So it's, for example, either murder or nothing. It's not going to be murder or manslaughter. However, there have been some other areas of law that have changed, that have allowed a bit of flexibility on this. And this is an AA star point, so I'll go through that with you in a second. So there are some contradictions in this defence. Now, what I've done again is given you the key points for this area. So I've used the headings from the mind map and I've made my points here. I've put the AO1 this time in bold, and then my discussion around that. And note that I've linked to potential questions in every paragraph. Make sure that that link is to the specific question that you asked in the exam. So I've talked about the subjective nature at the top. If there are any cases that you're not familiar with, by the way, please do make sure you look them up. There's a good website called eLaw Resources online which you could look at. So I've got these 3 points here. Please do make sure that you take your time to write those down and look at them. And then I've got my final 2 points on this slide. The one I just wanted to talk to you about is the 5th one, because I think this is a really important point, and this is something, if you talk about it, could really impress examiners. So as I said before, the defence is all or nothing, which means you're either fully convicted of the crime or fully acquitted, which makes it stricter in nature, because a jury, of course, a judge will advise a jury, if you believe this defendant acted in self-defence, they receive a full acquittal, they walk away. So it is harder to succeed on, and the Law Commission has written previous reports about this. And In 2009, the Law Commission reformed a set of defences to murder, which are what you probably know them as voluntary manslaughter. So, diminished responsibility and loss of control. Now, when loss of control used to be called provocation, so you could kill when you're provoked, which could give you a partial defence. So basically, it reduces your liability from murder to manslaughter. In 2009, through the passing of the Coroner's Justice Act in that year, the Law Commission, and the Law Commission is responsible for these changes, by the way. So Parliament passed the Coroner's Justice Act. They changed the name of provocation to loss of control. They felt probably it was more of an apt term. So you can kill somebody through losing control. Okay. Now there are two ways that you can lose control by law now. It used to only be you can kill as a result of the victim doing or saying something that provokes you or causes your loss of control. The second way that's been added is you can kill through fear of serious violence by the victim. Now that sounds similar, doesn't it? That sounds familiar to self-defense. You could technically kill somebody where you fear serious violence by the victim. So this added what they call qualifying trigger for the use of loss of control for murder is almost, well, pretty much identical to using self-defense. But what it gives you is a partial defense because loss of control is not a full defense to murder. It reduces your liability to manslaughter. So where the Law Commission has criticised for years self-defense being all or nothing, what they've done is dealt with their concerns where murder's concerned with adding an additional part to loss of control. So it widens the availability of the defence of self-defence to those who commit murder. I mean, the defence is still all or nothing for other offences, but at least it remedies that. So this could potentially make it a bit more fit for purpose, more just outcomes. Somebody like Tony Martin, when he raised self-defence for killing the intruder, he could, at that time, have potentially raised loss of control and maybe ended up with a partial defence instead of a full conviction. Speculatively, of course. So I hope that helps. And I've done another slide similarly to consent on whether self-defense achieves justice, okay, which again can help you with your nature of law parts as well. So it's a substantive law, and it was originally common law defence, but it has been codified. So that's a good thing about self-defence. It's one of our only defences in our legal system that has actually been put into legislation. Please don't forget that. It's available to those who genuinely make mistakes and less intoxicated. And that point is really about protecting the public. So if you're talking about legal principle versus public policy, which is one of the themes from the beginning, the need to protect the public from those who voluntarily become intoxicated, this law does that. You cannot mistakenly use force against somebody if you're drunk and you believe that they're attacking you. Giving homeowners more power to defend their properties, defend themselves in their homes, could again provide justice. And of course, the addition of the fear trigger for using the defence of loss of control could potentially achieve justice as well. So all those points that I've talked to you about are on this slide. So I hope you find those relevant. Be mindful that whenever I'm giving evaluation points in these slides, I'm always backing them up with law. You see, every point has law within it, and that's really what I want you to practice. Okay, final tips from me. I've talked far too long. Recite and learn your key law. Make a mind map with key evaluation points. You can use any from this tutorial. Keep reviewing them daily. The more you go over something, the more likely it will stick. Aim for at least 4 evaluation points in an essay. So 4 paragraphs of discussion. So you could pick 4 from my consent points and 4 from my self-defence points. And make sure, remember, you're going for 4 or 5 key law citations. Practice linking these points to different essay themes. So justice, fairness, purpose, effectiveness. Always conclude and suggest reform at the end. So I hope that has been useful for you, and I wish you all the best of luck with your exams. Do not forget to make your practice timed. Timing is critical for exams, planning and writing. Thank you very much.